Hello, this is Elliot Schlissel, foreclosure defense lawyer. Today I'm going to talk about a judge sanctioning a bank for foreclosure activities, and thereafter an appeals court reversing that judge's decision. John Lucido had been a mortgage broker and had taken out a mortgage loan in March of 2007 of about $500,000 regarding his home in Rocky Point, Long Island. He was unable to make his mortgage payments, and in 2009, Bank of America brought a foreclosure lawsuit in Suffolk County against him. There were numerous foreclosure mediation conferences. However, Lucido had been ill. His wife had died during the course of this litigation. This complicated the issues that were dealt with at the foreclosure mediation conferences. At the time of the foreclosure mediation conferences, Lucido represented himself. The conferences were held pursuant to New York Civil Practice and Law, Section 3408, which states, both the plaintiff and the defendant shall negotiate in good faith to reach a mutually agreeable resolution with regard to residential foreclosure lawsuits. Judge Spinner, sitting in a foreclosure court part in Suffolk County, ruled in April of 2012 that Bank of America had, quote, deliberately acted in bad faith, end quote. He had made this ruling because they had delayed 6 months in producing a pooling and servicing agreement. Judge Spinner also stated Bank of America gave material misstatements of fact which had been calculated to deceive the court and also cause delay of the court proceedings. Judge Spinner went on and held the bank had misinformed the court that the pooling and servicing agreement, which controlled Mr. Lucido's mortgage, specifically forbade principal reductions. Later, the bank acknowledged there was no bar to principal reductions in the pooling and servicing agreement. Judge Spinner, in his decision, forever restrained Bank of America from demanding, collecting, or attempting to collect, directly or indirectly, sums related to the $493,209 mortgage that were either interest, attorney's fees, legal fees, costs, and disbursements. He had held the bank could only collect principal and any funds advanced by the bank related to property taxes or insurance on the property. In addition, Judge Spinner imposed a $200,000 exemplary damages award against the bank. This cuts the bank's principal to $293,000. The bank appealed. The appellate division of the Second Department and Appeals Court overruled Judge Spinner's decision in its entirety. The appellate division held he did not have authority to impose that level of penalties against Bank of America. The appellate division held the bank's conduct did not justify the sanctions imposed by Judge Spinner and sent the case back to Judge Spinner for further legal proceedings. The appellate court took into consideration Lucido's unfortunate situation. However, they held the record on appeal reveals the conduct of the plaintiff in this case was not so egregious as to merit the imposition of sanctions against it. The fact Bank of America refused to give Lucido a principal reduction and they had delayed in producing documents did not, in and of itself, amount to a failure to act in good faith. My feeling about this case is that Judge Spinner's remedy was unusual, but there have been other cases that have upheld the tolling of interest when banks do not negotiate in good faith. I believe Judge Spinner was looking to send a message to financial institutions to be more cooperative at foreclosure mediation conferences. Unfortunately, the appellate division did not agree with him or me on this issue.